I'd like to welcome you on behalf of the Centre for Comparative and Public Law to today's lecture, which is given by Fiona Batt, with whom I've had a great lunch. And if the lecture is anything like the lunch, it'll be fantastic. Fiona's been telling me all about herself, so I know more than appears. Am I allowed to reveal it?
Yes, well, yes.
No. She was a farmer. Whatever the female is farmress?
I think it's just farmer.
Still farmer?
Yeah.
Okay, so Fiona started life as a farmer and then saw the error of her ways and decided to become a lawyer or a law teacher. So she took as a mature student, she took a LLB, LLM and PhD in UK, and then started teaching in the UK and then in Gambia. And I remember many times I used to teach in Uganda and people said to me, Uganda's next to India, isn't it? So I think Gambia is also pretty close to India, closer than Uganda is anyway, in West Africa. She's also worked at the Cambodian Centre for Human Rights, and I think you just come from Cambodia.
Yes, yeah.
She's written many articles, including Ancient Indigenous DNA, Intellectual Property Rights, and the African Regional Intellectual Property Organisation Schwaakopmund Protocol on the Protection of Traditional Knowledge and Expression of Folklore. I can't believe that title.
It's wonderful.
It's fantastic. Yes, 2 lines. And Fiona today is going to talk about a critique of the status of ancient indigenous human remains in international law, which we all know a lot about already, of course. Fiona.
Good afternoon, and thank you everybody for coming, and thank the University of Hong Kong for allowing me to present on the subject of ancient indigenous human remains and international law. And I thank Michael for taking me out to lunch. It was very enjoyable, and we had a good conversation.
We did.
Yeah. So, today we're going to talk about ancient indigenous human remains in international law and their status. Their status actually is very unclear in international law, and there's a need for a new conceptual framework. So my research and this presentation explores the possibility of a new conceptual framework. Why there is a need for a new conceptual framework is because I would say there's an absence of a legal framework, but the existing law, if there is any, actually doesn't give rise to equitable outcomes in disputes. And as lawyers, academics, that's not what we hope the law should achieve. We're all looking for equitable, fair outcomes. So the presentation's going to follow this path. We'll briefly look at Indigenous peoples, because there is a legal framework for Indigenous peoples in international law today. They are subjects of international law. Then we'll look at colonialism and the process of collecting ancient indigenous human remains by colonialists. And then we'll look at a potential legal framework. And then I'll conclude the presentation. Just bear this in mind as we're going through. In this presentation, I draw on 2 threads. I look at the status, but I also throw into the pot, and I don't wish to confuse you, a property theory called honest theory, which is quite a conventional property theory, but as an academic, I'm permitted to play around with theories. So I've actually turned honest theory on its head. And I couldn't totally explain that today, but just bear with me. There are two threads running through this presentation. So, I don't know if we're all lawyers here, but even if there are political scientists here, I think they'll understand this slide. International law never envisaged that the bones of Indigenous peoples' ancestors would be the focus of legal disputes. As judges, lawyers, academics, we're faced with new emerging disputes. Today we're faced with new resources that need legal regulation. So international law has had to accommodate and adapt to new legal situations on an ever-increasing basis. So just to place this in context, and I've got a slide of human remains here, and I hope nobody finds this inoffensive. I've deliberately chosen a slide of non-Indigenous peoples. These aren't Indigenous peoples' bones because Indigenous peoples would find it culturally inappropriate that I would put that on a slide. They actually find correlating databases on how many Indigenous peoples' remains are in museums culturally inoffensive. There are questions even in relation to a database on traditional knowledge. Oh, that slipped on then. So we're talking about actual bones. I'll just go back to that slide. So recently, Indigenous peoples have requested museums to return their bones taken in colonial times. And there have been cases where human remains have been readily given back to Indigenous peoples. However, some museums have refused to give the bones back, and I argue even delaying the giving back of ancient Indigenous human remains is inequitable.
Can I just disturb you for a moment?
Yeah.
Perhaps you don't mind if we do, since
No.
we're such a small group, we can...
Yeah,
I mean, at this point, I do have a question. I mean, would this involve, for example, are you talking about things like the Olduvai Gorge, you know, earliest human remains in Tanzania? I mean, are we going back to that sort of remains?
No, we're only talking about Indigenous human remains and taken in colonial times, so the 18th and 19th century.
So the sort of earliest
but we're not,
human remains would be excluded?
Would be excluded from my area. And I think it would be very difficult to make, for a peoples, to make a link perhaps with really ancient human remains.
Thank you.
Okay. So just to look at this area, Indigenous peoples, a lot of people say to me, well, I'm Indigenous, you know, where I live in Devon on Dartmoor. They say, you know, my family, I can trace my family back to the Normans. Well, in international law, that's not what we understand Indigenous peoples to mean. As I said, Indigenous peoples are subjects of international law. They'd be the Maasai of Tanzania and Kenya. They'd be the Sami of Finland, Sweden and Norway. They'd be the Aboriginal Australians in Australia, the Maori in New Zealand. And actually the Maori haven't been there for that long. They've only been there for about 700 years, but they're still classed as the first peoples of New Zealand. So there are UN treaties that contain the rights of Indigenous peoples. the International Labour Organization has a treaty. There's this fairly recent declaration, which is very, very important, the United Nations Declaration on the Rights of Indigenous Peoples. And I've just come from Cambodia, and they have a land law 2001, which contains the right of Indigenous peoples to register their land. However, they do have to fulfill rather a large number of hurdles to access that right, but it's actually contained in the law. The African Commission has a working group on Indigenous peoples, and what's quite interesting in Africa, and particularly in Asia as well, is generally states don't like naming these peoples as Indigenous peoples because it's linked to self-determination. So in the African context, they prefer the words populations and communities because it doesn't confront the integrity of the state so much. There are 2 UN studies. There isn't an actual definition, but the studies contain such terms as priority in time, marginalisation, different cultures, and this is how international law has distinguished Indigenous peoples from other peoples. So there isn't a definition. Globally, they're spread out through the world. They straddle borders. There are cases in domestic jurisdictions, and this is a famous case in Australia, the Mabo decision, which rejected the idea that when colonialists arrived in these lands, America, Australia, New Zealand, that they were empty lands, they were terra nullius. So Mabo put that aside, and it's accepted now that these peoples were living there before the colonialists arrived. And in relation to Indigenous human remains, America does have this piece of legislation which protects and returns Indigenous remains back to Native American peoples. So it's a legal concept. Also, just to get an idea in your mind about what I'm talking about, when I was in northern Spain presenting, actually in the area of human rights and ancient Indigenous human remains, the Guggenheim Museum had an exhibition of curiosity cabinets, and when I walked past this, it just jumped out at me and made me think, yes, this is what I'm talking about. Victorians, colonialists, they wandered the globe, you know, collecting objects of interest. However, why we're talking about ancient Indigenous human remains is that the bones of Indigenous peoples aren't flora and fauna. They're, you know, ancestors, they're family. They mean something else other than flora and fauna. I've moved my research not only into discussing the tangible bones of ancient Indigenous human remains, but museums today are actually extracting DNA from these bones, the intangible. So they're not only keeping the bones, but they're keeping the DNA. And it's culturally inappropriate, but also knowledge and economic resources can flow from DNA in the realms of intellectual property. And we'll look at that briefly in a moment. So you're probably asking yourself, why is this an area that we should bother about? You know, bones, they're lost, they're in museums. Indigenous peoples argue that the keeping of ancient Indigenous human remains, the keeping of their ancestors in museums, even though they're not displayed today, they'll be in boxes, in cupboards, you know, in cellars, continues the human rights abuses they suffered under colonialism. And actually, I argue the process of giving them back is as important as actually tangibly touching those Indigenous human remains. And there's a general argument with returning heritage that it leads to reconciliation and healing, and I feel that we can argue the same for ancient Indigenous human remains. When these peoples get their ancestors back and they can bury them or do whatever they wish to do with them, then it's the beginning of a path to reconciliation. And I also argue that ancient Indigenous human remains are linked to other human rights issues. For instance, self-determination, and that sounds quite a strong statement. However, post-colonial states were permitted and encouraged to request for their heritage to be returned as part of state building. It was a process, it reinforced the new state's identity. However, in relation to Indigenous peoples, it's quite complex, because Indigenous peoples, even though in the United Nations Declaration on the Rights of Indigenous Peoples, Article 3, there is a right to self-determination, it's actually held to mean something different than every other people's right to self-determination, which is, doesn't fulfill the human rights principle of non-discrimination. So I'm just arguing that by returning ancestors' remains, it could reinforce Indigenous people's right to self-determination, their right to land. It's just part of the picture. And in relation to Indigenous peoples, it is a holistic picture. We compartmentalise everything. Indigenous peoples have a holistic view of everything, and ancient Indigenous human remains are just part of that picture. So, that was an introduction, really. So there are actual legal disputes in this area. The first one here is quite interesting. It's colloquially called the Kennewick Man Case. I'm going to have to be brief, but basically some researchers found a skeleton in America, and the researchers wanted to study and extract DNA, which was culturally inappropriate to the group. It went to court, and the court found for the researchers. The researchers extracted genetic information and decided that the remains were related to people from Japan that potentially perhaps came from when the land masses were connected. So this undermined the local Indigenous peoples group ties with their land, because if a stranger had been found on that land, it meant that the Indigenous group weren't the first peoples there. So they lost control of these bones. However, last year in July, more researchers carried out on these bones, and they actually decided they were related to the local Indigenous peoples. So now the peoples have gone back to court, and they're trying to get their remains back. The Tasmanian Aboriginal case, my PhD actually is focused on this case. This was a case where the TAC requested their ancestors back. The Natural History Museum said, oh, okay, we'll give them back, you know, when we feel like giving them back. And we want to extract DNA. And the group said, please don't extract DNA, because it means breaking the bones and releasing the spirit, and the spirit would be released from home. So this went to the High Court for an injunction, and then it was resolved. The bones were given back and the samples of DNA. But the delay is, as I said in the beginning, for me is as bad as non-return. Because almost all were taken without consent, and all of the bones would have been taken without free, prior, informed consent, which is an international legal principle now. You know, consent is quite complicated. Today also the Anu from Japan, they live in Japan, they're an indigenous peoples, their bones were collected, and they're asking museums for them to be given back. These bones were collected to illustrate a difference in peoples, a hierarchy in peoples. It was linked with Darwinism. And when I was in Cambodia, I found out that the Penong people in Mondulkiri, they bury their bones in the spirit forest, and there are no markers. And now these forests are being leased to companies under something called an ELC. And these companies, it's not deliberate, but they're digging up the bones accidentally. This actually isn't a dispute, but it could be one in the future. And I'm just pointing you to Judge Trinidadi, who was in the American Court of Human Rights. He's now in the International Court of Justice. And he writes brilliant dicta. He talks about the spiritual manifestations of human beings. And there are a few cases in South America of massacred indigenous peoples. So with this case, we'll be talking about contemporary bodies and contemporary bones, relatives asking for their return.
May I just interrupt you again for a moment? When you talk about the human rights aspect, is it the human rights of the community, or the human rights of the person whose body it is?
Yeah.
Or both?
Both.
Both.
Well, I will briefly discuss the human rights area at the end, but the Hawaiian indigenous peoples believe that the bones of their ancestors are still part of the family, they're still living, and they've requested that they get locus standi in court under the Native American, the NAPRA, go back. This piece of legislation, there was a case where, so in that particular case, I think privacy was mentioned also. So that would be the human rights pertaining to the bones, and then you've got human rights issues pertaining to the group, the family group.
I mean, I was just thinking from the point of view of a land lawyer, and Andrew would probably have a view on this one when it comes towards you. But I mean, if I buy a piece of land and I discover there are some ancient bones buried in the land, I mean, I've just no idea how one would approach it. I mean, do I now own the bones with the land, or are they?
I believe in common law, you would.
But this doesn't impinge upon your principles that you're setting out today? I mean, have you got here a conflict between the common law and the approach of the international law?
A conflict between the international law and common law. There's not much common law there's obviously not a lot of common law in relation to this, but your question is about land.
I mean,
who would own the bones?
Yes, if common law says I own the bones,
Yes.
but the ancestors say no, we should have the bones.
Yes.
There seems to be a sort of conflict between
Yeah.
them.
But there's a resolvable conflict in the way if it's an interesting question.
Sorry, I withdraw it.
No. We'll talk about it when I get to the end. We'll talk about it.
Sure.
Because it's linked to land, ownership of land. That's what I argue. So basically, I'm saying it's a sui generis area. It's unique. There's nothing like it. Ancient indigenous human remains don't fit anywhere. It's a square peg in a round hole. And I also say, I'm not going to go through all of this, but there's a mismatch of perspectives between the non-indigenous perspective and the indigenous perspective. And I've got a range of examples here, and I think you can access my PowerPoint. And these range of examples are threaded through the rest of the presentation. So to unravel the status of ancient indigenous human remains, I've taken this approach, and I can support each paradigm as we go through. It's a mix of indigenous perspective and a non-indigenous perspective. And then I've also layered on this property theory of honours theory to develop a new conceptual framework. Now, honours theory talks about a bundle of incidents. I'm sorry, I don't like that word incident, so I've supplemented it for sticks, because in my mind I can see a bundle of sticks, and it's another way property writers view property anyway, a bundle of sticks. And with the status through those number of legal paradigms in the last slide and the bundle of sticks approach, I've hoped to develop a different conceptual framework that's more equitable. So disputes may be resolved more equitably. So these columns don't correlate at all, but honours theory would talk about the right to possess, the right to use, the right to manage, the right to the income of the thing, etc. Indigenous peoples talk about custodianship, not ownership. They don't have paper title, everything's orally handed down. They collectively own their land and everything in their life. The land isn't transferable, whereas the non-indigenous perspective of property is that it's transferable. So why am I talking about property? You're probably thinking, why do I keep talking about property? I argue that ancient indigenous human remains have been viewed by museums as property because they see themselves as the owners. They keep them, they manage them, they extract what they want from them, whereas indigenous peoples view their ancient indigenous human remains as custodians. They see them as part of their family. Interesting, the legal rule in relation to bodies and body parts is that there's no property in the body. That's the common law rule. However, with recent advances in biotechnology, I don't think that rule can be argued to be realistic anymore. And there are a number of common law cases. I've got here R.V. Kelly, which was a case in relation to body parts, where the judge noted a number of exceptions, but one exception was the fact that in the future that DNA would be an exception to the no property in the body rule. So that allows me, I think, to determine that ancient Indigenous human remains are being viewed by museums as property, and it's helpful to my argument. But also, you can look at many common law cases. This is a non-Indigenous case, John Moore, and just quickly, this man had his spleen taken with consent, and then scientists did some research on the spleen, and the outcome anyway was the development of the Mo line, which benefited the scientists by about £1 million. And of course, Mr. Moore wanted some of that money, but the court said when Mr. Moore gave his spleen with consent that there was no property in the body, and it was the fact, in relation to intellectual property law, it was the fact that the scientists had taken something and done something new, innovative, which had industrial applications. So it became something different. So he wasn't entitled to the benefits. Indigenous, so the first, or the umbrella paradigm we looked at was property. Under that heading, Indigenous peoples and museums generally say their bones are either cultural property or cultural heritage. That's what both groups argue. However, if you look at all the cultural property treaties and read them inside out, you won't find any reference to ancient human remains or ancient Indigenous peoples. So really, on its own, this framework isn't that useful. You know, people are saying, Indigenous peoples and museums are saying they're cultural property. However, in law, they're not. The same with cultural heritage, except for the Underwater Convention, which talks about human remains, I believe, 100 feet underwater. But that's still not very helpful on its own. Collective heritage. In law, there isn't a framework called a collective heritage framework in international law from a non-Indigenous perspective. However, if you look at it from an Indigenous people's perspective, again, yes, it's turning things on its head. You can develop a framework that contains an Indigenous people's perspective of ancient Indigenous human remains, however, without the force of law. But all these elements, you can look in cases from the Inter-American Court of Human Rights and the African Commission, and domestic cases from Canada, America and Australia, and you can develop a framework. As I say, without the full force of law, and on its own, not very helpful. But as we go through, I argue that we can develop a jurisprudential, an instrument toolkit. You know, you don't throw away the baby with the bathwater. You try, rather than seeing dichotomies, which we all love seeing, and saying that doesn't work, that doesn't work. We try and use what we've got. People think this is a bit strange to attach intellectual property to ancient Indigenous human remains. However, DNA's been taken, and one day something will be discovered, you know, with new biotechnology. And this is an American case, the first case, where the judge said anything under the sun made by man can be patented, you know? And this next case, if you've ever got time, it's very interesting. Lord Hoffman really illustrates the dilemma with the perspectives, the non-Indigenous and the Indigenous perspectives. It's an intellectual property case, and he examples the discussion by talking about an Indigenous group who see something as chinoa bark that cause a disease, that cures an illness they have, and the non-Indigenous perspective of quinine. So the Indigenous group will see it as bark, and the non-Indigenous group will have a different perspective, quinine. The trade-related aspects of intellectual property rights, because we're talking about international law, it's a very, very long treaty and isn't helpful towards Indigenous peoples' property rights at all, and it's been much criticised. The Convention on Biological Diversity is more Indigenous friendly. So I'm just trying to develop a toolkit as we're going through. Traditional knowledge. I argue perhaps we could draw on the traditional knowledge legal framework, which is in its infancy, and the World Intellectual Property Organization have been grappling with an instrument or instruments to protect the traditional knowledge of communities, Indigenous peoples. And they're having a few problems, and they've been criticised for lack of participation of Indigenous peoples. However, if you look at the African Region Intellectual Property Organisation, they're quite a forward-looking intellectual property organisation, and they have this protocol, the Swakopmund Protocol, which I love, which is very Indigenous peoples friendly, and it includes things like collective rights, transboundary. It recognises that Indigenous peoples don't live in states, you know, they straddle borders, so that's a very interesting protocol. But on its own, not that helpful. And now we reach the human rights-based approach, which Michael was discussing. And really, it's helpful to look at this approach against the United Nations Declaration on the Rights of Indigenous Peoples, because that declaration contains, firstly, repatriation mechanisms. Although it is only a declaration, it's been quite influential. And I also argue there are associated claims like self-determination and land. And we can talk, the land claim is linked to your, what if I find bones on my land? And spiritual health. Spiritual health actually isn't a principle contained in international law. In the Declaration on Indigenous Peoples, spiritual health of children is mentioned. However, non-Indigenous perspective, you'd be more familiar with perhaps the right to religion or the right to health, but spiritual health actually encompasses more of an Indigenous perspective of their ancestors' bones. And if you look at the declaration, I argue that the non-Indigenous perspective of cultural property, heritage and intellectual property has to be read differently within the declaration, and all those terms are contained in the declaration, in an Indigenous Peoples United Nations declaration. So what am I trying to say? I'm saying that the law in this area is fragmented. It's a bit like the common law. We have to look for it everywhere. And that's not necessarily a bad thing from my approach. And the International Law Commission has actually noted that fragmentation isn't necessarily negative. It's a way of managing new arising situations, because as we all know, if we decided we needed a new treaty for every new emerging situation, it would take forever. The Law of the Sea Convention took ages. And big states are not signatories to that treaty today. WIPO have been grappling with a traditional knowledge instrument, and it's very slow. And if you look at the ILO convention I talked about right at the beginning, which contains the rights of Indigenous peoples, there are only 22 signatories, so that's not that helpful. So I'm arguing that if we follow this approach, it's not an answer. I call it an amelioration. You have a toolkit. You know, rather than throw things out, try and draw positive elements out of all these legal paradigms. And by turning honest theory on its head, recognising there are different perspectives as well, even though they're not legally binding, might lead to more equitable solutions in disputes. So thank you very much.
Okay, chaps, over to you. We've got, I've not got a watch, I've had my watch stolen from me. We've got just over 10 minutes if you have some questions for Fiona.
My name is Jason, and I'm from the Faculty of Law from the Chinese University of Hong Kong. Thank you for making such an informative presentation. I've got 3 questions I want to ask.
Okay.
The first question is that you talked about the repatriation of human remains to Indigenous peoples.
Yeah.
And what I want to ask is that can your approach or theory be extended to include the repatriation of cultural artifacts of Indigenous people, for example, the bark paintings of the Aborigines of Australia, or or other cultural artifacts, or does your approach, you want it to be constrained within only the repatriation of human remains? That's my first question. My second question is that with regards to the repatriation of human remains, one of the main reasons why you argue that it is important is because by repatriating these remains, you can, it's a method of creating reconciliation and fostering self-determination amongst these Indigenous peoples, and also as an act of letting go of these colonial powers, past of colonial oppression towards these Indigenous peoples.
Yeah.
However, my question would be, if, say for example, there are human remains that are kept by a museum of an Indigenous people that has been driven to extinction by these imperial powers. If that is the case, then the question of repatriation becomes whether this repatriation is for the benefit of the Indigenous peoples, which in this case might no longer exist, or whether it's merely as an attempt for the colonial powers to atone for their past sins. Whereas, and I would argue that in this case, whether or not they're repatriated, it might not make a difference because the subjects of their oppression no longer exist. And my third question...
Stop.
Yes.
They're not related, so let's deal with them one by one. Okay, but they're very good questions.
Yeah, they're very good questions. The first question, and I'm glad you asked it, because without this, I think this could be useful with all Indigenous resources. And actually, I'm setting up a project in relation to West Africa, well, Africa. I think this could, because one academic says half of Africa's cultural property is outside of Africa, because it's very expensive following museums, correlating who's got what, where it is. So I think this approach can be used with other Indigenous resources and other problematic areas, and African cultural property is one of them. Your second question, I'm not aware, but you're probably correct that there have been groups that have been hunted to extinct.
An example would be the Chatham Islands natives. They were more or less killed off by first the British and then the Maoris. They live on an island near New Zealand.
Okay. In a case like that, I mean, I don't know who would be requesting, because museums won't do anything without a group making a request. And in relation to the Tasmanian group, if you read the literature, it will actually say that, and you know, I don't want to offend Tasmanian Aboriginals, but some would say a genocide occurred there, and actually it was only the intermarrying with the invaders that continued that Aboriginal culture. But they're still requesting their bones back. But probably some bones will sit in museums forever, and some groups may not want their bones repatriated. It may not be a big concern because they're still trying to hold on to their land. So, your third question?
My third question is that with regards to your new bundle of sticks theory and the prevailing approach by Indigenous groups, which is to approach the repatriation of their human remains found through cultural property or relevant laws, do you think that there is a need to do outreach to promote your reconception of the repatriation of human remains to the Indigenous groups that you're working with?
Yes, this was my PhD, and actually I've been asked to set up a different, I mean the African cultural property I'm doing on my own, but I've been asked to set up a project around this area, but I haven't had that meeting yet because I've been travelling, but I think it is an approach that could be used, and there's suddenly some activity in this area about repatriation. Yes, so something for the future. Thank you, your questions were great. Thank you.
What do you do?
Oh,
the Chinese youth.
I'm a PCLL student at the Chinese University.
You should be here.
Yes.
What are you doing over there?
That's right. You should get him here.
You're very impressive.
Thank you.
Well done, Joseph.
Thank you.
Any more questions?
I have a question.
Yeah.
I was particularly intrigued by your response to Professor Wilkinson's question about whose human rights we're trying to protect here. Are we talking about the human rights of the deceased, or are we talking about the human rights of the relatives, the surviving relatives? And I'm interested to know your take on how you can extend human rights, which are relatively modern conceptions, to deceased individuals who predate modern kind of human rights law and international human rights law by centuries and, you know, sometimes millennia. I understand the nexus, or I can see the nexus between human rights and modern day relatives or descendants, but I'm not so sure about that nexus with the deceased, because how can you apply it?
Yes.
Post ex facto.
I mean, I'm not really applying it. The Hawaiian group were applying it. privity did come up, and they see these remains as living. They're still a living part of the family, and that's quite a general view of a lot of groups around the world. They do have similar views on their deceased relatives. And I'm only, I'm respecting their perspective.
I understand. I wonder whether before we can extend human rights to the deceased or to the bones, we need to buy in, so to speak, to that kind of that understanding of them as being a continued living presence.
Yeah.
And so whether there needs to be a bridge within law or external to law that can take us from where we are now
Yes.
to a place where we identify that that we recognise that cultural identification.
Yes.
And so that's
Yeah.
part of, I suppose, what you're
Trying to
Yes,
achieve without
proposing.
Making progress rather than stopping. And because some of us are aware of how international law works and participation, it's state-centric. I'll give you a little example. A few times I've met a Maasai leader at the African Commission, and I have to be careful what I say, but Indigenous peoples are getting a bit tired of all the talk. They want something to happen. And so I said to him, well, you just got to develop other strategies. If that strategy isn't working, then you try and come up with another strategy. And he said to me, yes, we have a proverb or a saying. When a tree falls in your path, you walk around it, and you find another path. And I suppose I was very mindful when I started this investigation that the dichotomy was attractive, but something in my mind stopped me being attracted by the dichotomy and just trying to find strategies to bring it all together. Thank you for your question.
I just have one comment, which is not helpful in any way,
Okay.
but the only thing you've said that quite disturbs me
Yes.
was the statement that there can be no property in a body. That just puzzles me. I mean, it seems to me contrary to common sense that you couldn't now, I mean, given all the DNA issues that are arising,
Yes, yeah.
I mean, that should just be reversed.
Well, it's an old common law rule, and it still stands, I believe, unless in the last 12 months, I haven't seen anything that a judge has overruled.
Seems inimical to
No.
progress, that
Well,
rule.
It doesn't make any sense to me now, and that's what I've said, I've written.
Andrew, can you overrule it?
No, I'm just very lowly, district court judge.
No, go for it. We'll try and arrange for a case to come before you on the issue.
And the Court of Appeal and the Court of Final Appeal will overrule me.
Any more questions? If not, this is wonderful timing. I'd like to thank Fiona very. I'm sure somebody will stay behind anyway to chat. Jason, you're very welcome to. Thank you for coming all the way
Yes,
from
thank
Chinese
you.
Jury. Very impressed. Thank you very much. Fiona, thank you so much.
Well,
It was
thank
most interesting, and I understood some of it anyway.
you. Good.
Thank you very much.